The following represent my own views and not those of the U.S. military. I'm Attorney David Villa, currently serving MD soldier for the Maine Army National Guard. I serve as a JAG, currently in a TDS role, which means I'm a military defense attorney. On the civilian side, I work with Ruane attorneys, and this is our guide to Connecticut service member arrest. The first thing you need to understand, you're now dealing with two completely separate legal problems at the same time. Problem one, your criminal case in civilian court. The state of Connecticut is prosecuting you. Problem two, your military status. Your command can take action against you independent of what happens in court. Winning your civilian case does not automatically protect your military career. The military can act on an arrest alone without a conviction. These two problems run on parallel tracks and both need to be addressed. Ignoring either one is a serious mistake. You answer to two different sets of rules. As a service member, the rules which apply to you depend on the type of duty you were on when the arrest happened. In some cases, even being completely off duty doesn't protect you from military consequences. When you're on a weekend drill or state duty, Title 32 orders, this is the most common situation for most Guard members. You fall under Connecticut state military law and the authority of your Adjutant General. Your chain of command handles disciplinary matters through state military code. The UCMJ, the Military Criminal Code, doesn't automatically apply in this status, but your commanding officer still has significant authority over your status, pay, and continued service. When you're on active duty or federally activated, deployed, on active duty orders, called up for a federal emergency, you fall under federal military law and the full UCMJ. In this status, the military can bring its own criminal charges against you in addition to whatever the civilian court is doing. You could face a court-martial and civilian criminal trial for the same underlying conduct, even if the arrest happened off duty. If you're on federal orders at the time, the UCMJ may still apply. You are required to report your arrest. Do this right. Failing to report your arrest to your chain of command is its own separate military offense. It can be treated as more serious than the arrest itself. You are generally required to report your arrest to your commanding officer within 72 hours. Your unit may require faster notification. Some commands require 24-hour or even immediate reporting. Check your unit's standing orders or your enlistment contract right now. Do not assume 72 hours is the deadline. You must report arrests, criminal charges, protective orders, restraining orders, and any legal proceeding that could affect your fitness for duty. Hiding the arrest and hoping your command doesn't find out isn't a strategy. It will come out, and the cover-up makes everything worse. Before you report to your chain of command, talk to your lawyer. What you say in that report matters and can affect both your military case and your civilian case. If you have a security clearance, you are required to self-report your arrest to your security officer. This is a separate reporting obligation from notifying your chain of command. Your clearance is not automatically revoked when you're arrested, but a review or investigation begins immediately. Failing to self-report a disqualifying event is itself grounds for permanent clearance revocation. The cover-up is treated worse than the underlying arrest. If your MOS requires a security clearance and you lose it, you can lose your MOS. Losing your MOS can start the process of separating you from the military entirely, even before the criminal case is resolved. If you cannot legally possess a weapon, read this now. This is the most operationally urgent issue you face. If a court has restricted your ability to possess weapons, you cannot show up to duty and handle military weapons. That is a federal crime. A protective order is issued at arraignment in virtually every domestic violence case. It happens the morning after your arrest. The moment that order is signed by a judge, federal law prohibits you from possessing any firearm, including military weapons. This isn't a gray area. It's a strict federal prohibition under 18 U.S.C. section 922G8. You cannot carry a weapon on duty, qualify on the range, handle weapons during training, or deploy to any situation requiring weapons. You must report this conflict to your chain of command. Do not show up to drill and hope no one notices. Your commanding officer will place you in a non-weapons role or suspend you from duty until the order is resolved. Handling military weapons while subject to a protective order is a federal crime on top of the military offense. Don't do it. A domestic violence conviction of any kind, even a minor misdemeanor, permanently bans you from possessing firearms for the rest of your life under the Lautenberg Amendment. There is no military exemption to this law. It applies to service members and veterans the same as everyone else. If you cannot possess a firearm, you cannot serve in any capacity that requires one. In practical terms, a domestic violence misdemeanor conviction ends your ability to serve in the military in most roles. The military will begin separation proceedings when they learn of the conviction. This is why a domestic violence case is the single most dangerous type of arrest for your military career. A plea that seems minor in civilian court could be career-ending in the military. If your driver's license is suspended after DUI, many service members have duties that require operating military vehicles, trucks, Humvees, transport equipment. A civilian DUI and license suspension automatically triggers a review of your military driving privileges. Military driving privileges are separate from your civilian license, but a civilian DUI is reviewed for its impact on your military driving status. If you lose military driving privileges and driving is a core function of your MOS, you may be reassigned or separated. A second DUI with a multi-year ID requirement creates an even longer conflict with your military vehicle operation. If you are convicted of any felony, a felony conviction triggers a lifetime federal ban on firearm possession, the same result as a DV conviction. You cannot perform armed military duty with a felony conviction. Separation proceedings are initiated in virtually every felony conviction case. What your command can do. Your commanding officer and your service have a range of tools available. Here's a full picture from least to most severe. Counseling and letters of reprimand. A written counseling statement or a letter of reprimand placed in your personnel file does not end your service, but it follows you. It affects promotion decisions, assignment opportunities. This is often the first step for a first-time, less serious offense where the civilian case resolves favorably. Demotion, reduction in rank. Your commanding officer can recommend or order that you be reduced in rank. This means lower pay and a loss of your standing as a leader. For NCOs, a demotion can significantly damage your career trajectory and your ability to re-enlist at your current grade. Suspension from duty. You can be suspended from attending drills, training, and activations while your case is pending. No drill attendance means no drill pay and no retirement points. Real money and real retirement consequences that start immediately. You may be placed on limited duty that restricts your access to weapons, sensitive materials, or leadership roles. Bar to reenlistment. Your command can place a bar to reenlistment on your record at any point during a pending criminal matter. This does not remove you immediately, but prevents you from reenlisting when your current term ends. If your case is not resolved before your enlistment expires, you can be forced to leave the service. Suspension of federal recognition. The Adjutant General can suspend your federal recognition, freezing your status and your pay. You remain technically in the Guard, but cannot drill, train, or receive pay or benefits. This is often used as a holding status while criminal proceedings are still pending. Involuntary separation. Administrative discharge. The Guard can move to separate you from the service through an administrative process. This does not require a court-martial. The type of discharge you receive has permanent consequences on your benefits, your employment prospects, and your reputation. Your discharge is a life sentence. It matters for the rest of your life. If the Guard separates you, the type of discharge you receive determines what you keep and what you lose. Here's what each one means. Honorable discharge. You keep everything. GI Bill, VA healthcare, VA home loan, retirement points, full veterans benefits. It's rarely used in a misconduct-based separation, only when the underlying matter is minor and your overall record is strong. General discharge under honorable conditions. Your service is recognized as generally satisfactory, but not fully honorable. Most veterans' benefits are preserved, but some GI Bill programs may be affected. It's a common outcome when your overall record is positive, but the misconduct can't be ignored, other than honorable, or OTH. The most severe administrative discharge issued without a court-martial. You will lose most veteran benefits, including GI Bill, educational benefits, VA home loan eligibility, and in some cases, VA healthcare. It creates a significant stigma in civilian employment. Employers and background checks will see this. It can be appealed for an upgrade, but upgrades are difficult and not guaranteed. Bad conduct discharge requires a special or general court-martial, a full military trial. More severe than an OTH, most or all veteran benefits are forfeited. It's treated like a criminal conviction in civilian employment background checks. Dishonorable discharge requires a general court-martial, the most serious military tribunal, reserved for the most serious military offenses. You will lose all veterans' benefits, every single one. It's treated as a felony conviction in many civilian contexts. You permanently lose your right to possess firearms under federal law. The military can also charge you separately. If you were on federal orders when the arrest happened, the military can bring its own charges under the UCMJ on top of your civilian charges. You can face both civilian trial and military court-martial for the same conduct. Common military charges that mirror civilian arrests. Article 128 Bravo, domestic violence, a specific UCMJ article added in recent years. Article 128, assault. Any civilian assault can also be charged militarily. Article 111, drunk or reckless operation of a vehicle, DUI while on federal orders. Article 112 Alpha, wrongful use or possession of a controlled substance, a drug arrest. Article 133, Conduct unbecoming an officer for commissioned officers, Article 134. A general article covering conduct that brings discredit to the armed forces. Remember, winning your civilian case does not stop the military from bringing its own charges. What you've built that could be lost. Your service has value beyond a paycheck. Here's what's actually at stake. Let's talk about some Guard-specific benefits. Military retirement. Guard members who serve long enough earn retirement points toward a pension at age 60. A bad discharge can wipe those out. GI Bill. Education benefits you have earned or are earning. An OTH discharge or worse typically eliminates eligibility. VA healthcare, access to the VA medical care. A dishonorable discharge eliminates this entirely. VA home loan, the ability to buy a home with no down payment using your veteran status, forfeited with a dishonorable discharge. Life insurance, SGLI, coverage for other service-connected benefits are affected by discharge type. Over a lifetime, these benefits can be worth hundreds of thousands of dollars. The stakes of your criminal case go far beyond a fine or probation. What you need to do right now, do not handle this alone. The decisions you make in the next few days can affect both your freedom and your military career permanently. Step 1, get a civilian criminal defense lawyer immediately. Your civilian case must be handled by a lawyer who understands how the criminal case outcome will affect your military status. A plea that looks acceptable in civilian court can be a career ender in the military. Your lawyer needs to understand both sides before any plea decisions can be made. Step 2, contact your unit's JAG office. Your unit has access to Judge Advocate Generals, or JAGs, attorneys who handle the military side of your situation. JAG attorneys are separate from your civilian lawyer. You may need both working together. Contact your JAG office as soon as possible so the military side of your case is being managed. Step 3, report to your chain of command, but talk to your lawyer first. You are required to report your arrest, but what you say in that report matters. Talk to your lawyer before you make any formal report to your chain of command. Know when your unit's reporting deadline? Check your standing orders today, not when the deadline's already passed. Step 4, if a protective order is issued, address the weapons conflict immediately. If a domestic violence protective order was issued, you cannot handle military weapons. Report this conflict to your chain of command now. Do not wait for the next real date. This is the most time-sensitive issue you face, and ignoring it creates additional federal criminal exposure. The bottom line, you've served your country and your state. That service and everything that comes with it is worth protecting. A criminal arrest does not automatically end your military career, but the decisions made in the days and weeks after the arrest can. The civilian legal system and the military system run separately. You need to manage both at the same time. Get a lawyer who understands what's at stake on both sides before you make any decisions. Do not plead guilty to anything in any court without fully understanding what the plea means for your military career. That's it. Once again, I'm David Villa with Ruane Attorneys. If you're facing charges in Connecticut, give us a call for a free case evaluation and we'll tell you how we can help.